This morning is George Santiago versus State of Florida. It's number 25-1003. So counsel, you may take your time getting set up. Counsel for the appellant, Mr. Santiago, whenever you're ready. Before we begin, how much time would you like to save for rebuttal, if any?
5 minutes would be fine. Thank you. May it please the court. Good morning, Your Honors. Eric Soris on behalf of the appellant, Mr. George Quinones Santiago. This court should reverse Mr. Santiago's judgment and sentence for the reasons stated in our initial and reply briefs. Although for purposes of oral argument today, I'd like to focus the majority of my time on issues 1 and 3 as labeled in the briefs. That is the trial court's ruling on the initial motion for judgment of acquittal after the close of the state's evidence. And the third issue being the trial court's evidentiary ruling that the door was open to otherwise inadmissible evidence. Taking the first issue, quite simply, the issue boils down to the state in its charging document charged a specific crime, that is trafficking in fentanyl. However, the state's evidence established an entirely different controlled substance.
Did the charging document need to specify that it was a derivative of fentanyl versus fentanyl? Did the charging document, I know it did that, I know it specified, but did it need to be that specific?
So, yes, Your Honor. In light of Section 893.135, which delineates the different controlled substances that the state can pursue in a charge like this, it's our position that when the state did delineate in its original information fentanyl or a mixture containing fentanyl, and specifically cited 893.03, I think it's B9.
2B9. Yeah.
2B9. There's a lot of statutory provisions in this argument, so bear with me. That they grounded their case, the state grounded its case in fentanyl. And as I'm sure the court is aware, the testimony as it was adduced at trial and the FDLE expert testified that parafluorofentanyl, which was the substance that was introduced or established at trial, is not the same as fentanyl or a fentanyl derivative. Now,
she does say that though, right? So the FDLE agent says, I don't have it in front of me, right? She says, this is a type of fentanyl. It has one more atom. It has like a fluorine, right, attached to it. And so then it becomes parafluorofentanyl. And she doesn't say, I don't know if she says derivative of fentanyl, but she has testimony in there saying it's fentanyl, okay? I think this statute is a little bit wonky in that, and when I say that, I mean 893.135, I had it memorized, 1C4A, okay? It has, under Roman numeral 3, which the state picked, fentanyl, okay? But then later, it characterizes all of these Roman numerals and says that if you have, right, one of those, a person who knowingly sells, purchases, manufactures, etc., 4 grams or more of one of these Roman numerals commits a felony of the first degree, which felony shall be known as trafficking in dangerous fentanyl or fentanyl analogs. So it's like, it's defined, fentanyl could be that, and then it would be trafficking in fentanyl, or one of the other ones would still be trafficking in fentanyl. The reason I'm asking you this is I'm not sure, do they just have to prove one of them, but they just have to prove fentanyl, and then the jury instructions will say 4 grams or more, knowing possession of fentanyl, and you could just pick one of those. It seems like fentanyl is the element and not one of those Roman numerals, if that makes any sense.
well, I think it does. I think what your question gets to, Judge Brownlee, is that when the state elects to specify a specific controlled substance, as it did in its original information, that it's required to prove it as charged. And there's a myriad of cases that stand for that proposition. The Morgan case, the JB case.
I think that, I mean, it's an easy call if it's cocaine and fentanyl, right? That's easier. I'm like, oh, you just said cocaine. Now you've just described a different type of fentanyl, and I have an agent telling my trial court, or our trial court, right? She's saying it is a type of fentanyl. And then they're like, we just had to prove fentanyl. And he says JOA denied.
Sure. So a couple responses to that. And the first thing I'd like to kind of acknowledge with the court is that there appears to be this inclination to treat these controlled substances as one and the same. I think that's kind of, Judge, what your question is getting
Right,
at.
okay.
But in light of the statutory text and the way that the Florida legislature has delineated these different controlled substances, they're not the same. And I understand it's tricky when the substances that we're talking about, at least in part, share the same name, right? But the statute at issue, or the statutes at issue, delineate these controlled substances differently. One is a Schedule 1, the other is a Schedule 2.
And tell me why does that bear on sentencing, or is that bearing at all on the conviction? Like the scheduling, setting aside for a moment your argument that these two are different substances. I understand that's necessary to understand. But for purposes of the schedule, we've got fentanyl that has medical purposes, and then we have the derivative that does not, right? Does that really just matter for sentencing purposes? Like one, you get an increased sentence, or does the schedule matter for conviction?
I think it's the latter. At least in this instance, the sentencing scheme or the proposed, possible exposure or punishment was the same.
Okay.
So yeah, right. It's a 7-year minimum mandatory for either. But I would point out that even in the sex offense cases, where the state could charge one theory of a sex offense based on which body parts were touched or in which manner the sex offense took place, and if that is grounded in an information, then the state is required to prove it that way at trial. Regardless, though, of which body parts were touched or which way the sex offense was carried out, the punishment's the same. So I don't think the punishment necessarily is determinative in this context. I think it goes to the crime. The Florida legislature has chosen to delineate these substances separately. In fact, even in 893.03, they define a fentanyl derivative as excluding fentanyl. So while it might sound counterintuitive, fentanyl and perifluorofentanyl are different controlled substances.
Counsel, you just said something important I want to understand. I agree with you that the legislature has chosen to allocate these differently. They've delineated fentanyl and perifluorofentanyl in the Roman numerals. But what I heard you say is if they've chosen one in the information, that it has to be proven. It's not superfluous. Does that make it an element? And my other question is, if they hadn't put it in the information, if they had not delineated in the information, would we be here? If it had just been blank, if they had just said you are charged with violating 4A, and they hadn't gone out of their way to say subsection 3, fentanyl.
So the short answers to both of those questions, Judge, is yes to the first and no to the second.
Is the first yes because of prejudice, or is there a legal reason besides prejudice that they have to prove it?
Well, the first is that this is, so I'm not sure I understand. So the first question you asked was, is this an essential element to the crime?
Correct. Sorry.
Our position is that it is.
Okay.
And I think that's supported by the jury instructions, which require the state to establish that this substance is, after the amendment of the charge here, in this case, a fentanyl derivative. Originally, it would have been fentanyl. And not only that, I think the jury instructions on the lesser included offenses substantiate this argument. So under the original information, it would have been simple possession of fentanyl. That changed after the mid-trial amendment, and now it's simple possession of a fentanyl derivative. So I do think it's an element of the crime.
But I'm not sure the prosecutor had to charge it that way. I mean, I think when he goes back, and I don't know, I mean, I appreciate that this is speculation, but he goes back and charges it under the same statute, right? And then does, 1C4A, and then says a fentanyl derivative. I mean, if you're gonna, I don't know, I just think that's a highly specific. I think you're like typically looking at these informations and saying trafficking in fentanyl, and then all of these count. But
So-
I don't want to interrupt your answer to Judge Nardella's important
No, I
question,
think
but,
that's somewhat related. I think the fact that the state elected to specifically ground this criminal offense in 2B9, specifically mentioning fentanyl or a mixture containing fentanyl, they boxed themselves in on that criminal offense. It's the same thing in the context of the resisting cases. If the state charged a resisting arrest against Officer A, but the evidence at trial was that the resisting was against Officer B, then the state hasn't proved the crime as charged.
but if you change the address of the location that was robbed, it's no harm, no foul, right?
Sure, but that's because it doesn't substantially prejudice the defendant.
Well, that's what I'm saying is I think these things are really case specific and unique. So when you're going, if you guys are all going to trial and you're going to build the jury instructions and you're having the charge conference for the judge, and we all know that, like I would always pull it from the Florida Bar's website, and it says insert specific controlled substance, and you're going to map out your jury instructions for the judge and say, I've got a trafficking and fentanyl case. What does that look like? Say they picked parafluorofentanyl correctly the first time, they say fentanyl derivative. Are you guys going to build those jury instructions where it says enter controlled substance and you're going to put 4 grams or more possession of parafluorofentanyl, or are y'all going to put fentanyl?
Well, I think in this instance, that's kind of what happened, right?
I
So
know,
the-
I just think, is that what always happens? I mean, I think when he amended that information, he got really specific with it. I don't know whether that was necessary or not, and I think whether it's necessary is the key thing in this case.
Sure. And I recognize that some of the sub-issues under this JOA argument only become relevant if the court accepts our premise that it was charged incorrectly and the state's evidence didn't support that specific charge. But Your Honor, the jury instructions did in fact start with fentanyl. And the state's mid-trial amendment to conform to the evidence of a separate and distinct, as the FDLE analyst described it, a different controlled substance. That just goes to show that there is a difference between these controlled substances and that the state felt it necessary, in our view, and as our briefs describe it, almost an implicit concession, that it had to amend its information to conform to the evidence because those controlled substances were different.
All right, what about how the jury instructions say, 4 grams or more, whatever it says, and then of a fentanyl derivative, and then they instruct the jury, right, as a matter of law, parafluorofentanyl is a fentanyl derivative. So wouldn't it be, couldn't you envision another case where you say, all right, state alleged parafluorofentanyl, and we're going to instruct them on parafluorofentanyl, and then you say 4 grams or more possession of fentanyl, and then this jury heard parafluorofentanyl all the time. So you say, just like they did in this case, parafluorofentanyl is a type of fentanyl. But wouldn't that take care of it? And it's not really an element. You're helping them with the case and the manner in which the state proved it.
Judge, I think I would have to fall back on the way in which the legislature has delineated these different controlled substances.
I know, but then the legislature swoops them all in. I'm hogging this oral argument, judges. It swoops them all in at the end and says, if you do any of those, you're trafficking in fentanyl or fentanyl analogs. And in fact, seems to be so unconcerned about the specifics that in Roman numeral 6 and 7, it's sort of broad. It's like a controlled substance analog of any substance described, a mixture containing any substance. So it's like, these are all trafficking in fentanyl. It feels like that's the point, but I'm troubled that the state put this in the information, then didn't prove it.
I think that's the gist of this argument, Your Honor, is that, and it goes back to Judge Nardella, what you mentioned, is would we be here if the original charging document didn't specify a specific controlled substance, fentanyl? I frankly don't think we would.
Counsel, can I ask you this is sort of an order of operations question. Assume that we agreed with you that the state failed to prove an essential element at trial and that you would have been entitled to the judgment of acquittal. But the state says, like in the Thatch Supreme Court case, like, yep, we think that the defense has a point. We're going to amend our information to include the thing that we did prove. And then we enter into a different analysis, which is the mid-trial amendment is permissible unless it prejudices the defendant. So do we have to reach the question of whether you would have been entitled to the JOA, or do we now have to focus on the amendment because the trial court granted it, rightly or wrongly, and just answer the question whether it was right or wrong to grant the amendment? In other words, which issue do we have to decide, or are they so tied together that we still have to decide both?
No, I think the court only has to turn to the prejudice of the mid-trial amendment if the court agrees with us that the state charged substance A but only proved substance B, because then that question becomes relevant, Your Honor. A mid-trial amendment to conform to the evidence is only permissible if it does not prejudice the defendant. And in this record, I think there's little argument from the state that there was any prejudice, was not any prejudice. The trial counsel below went as far as to swear himself in and essentially proffer the prejudice that occurred in this case.
And is that prejudice is tied 100% to the speedy trial issue, correct? Well, let me back up, and I'll you correct me if I'm
90%,
wrong. A decision was made to not waive speedy trial,
Right.
with the understanding that, we've seen the discovery. It looks like all they're going to be able to prove is parafluorofentanyl. They've charged him with fentanyl. Let's go to trial, put them to their evidence, and assuming they prove what we think they're going to prove, we win. Whereas if that decision hadn't been made, you could have waived speedy trial. You could have called this to the attention of the prosecution. You could have done other things and really worked up the case to defend against parafluorofentanyl. But a decision was made not to do that.
You're right. Strategic decision to proceed based on how we would describe it, a charging defect. So once he sees what he's charged with, this is the trial lawyer. Once the trial lawyer understands what the defendant is charged with, and then in the discovery sees it's a completely different substance, it's a strategic decision to move forward.
But that's strategy, right? That doesn't bear on a defense that's chosen. Like, it becomes problematic, I would think, if you've, and the cases talk about this, like, well, what would have changed about the defense? This is just putting all your eggs in one basket, right? And I get it. But, when you look at like prejudice cases, it's, well, I have an alibi defense. And you said that I robbed the bank on January 23rd. And so I developed my alibi for January 23rd. And now you've changed it. And my alibi defense goes away. And now you've picked a new date. And I don't have any defense to that. Like, there's no defense. It's just putting all your eggs in one basket.
So I would agree in part, Judge, that at least in this case, the defense was entirely centered around the difference in the substances. But I think procedurally, there's a lot of prejudice here, too, that the court should consider. That being that the defendant invoked speedy and filed a notice of expiration to effectuate that timeline. Not only that, as the trial lawyer testified to below, he elected not to pursue certain pretrial actions. So there was no depositions taken. There were no plea negotiations. There were
But
no
I mean,
motions to
that's a
suppress.
huge risk, and it was a knowing risk, right? And does
Sure.
that matter? I mean, in the case law,
Well-
having notice seemed, so he knew it's a risk. And he's, you could have said, we got to get some of these depots done. We didn't waive speedy. Hey, Judge, I'd like 5 minutes to go depose the guy. Whatever it is, he knows that he's got the problem and then doesn't do anything.
Well, I'm going to mention I'm
Yeah,
quite,
counsel,
quite a
keep
bit
going.
into my
I'm sorry. Go
rebuttal
ahead.
time, and I'll do my best to.
Well,
Yes, Judge?
I will give you back 2 more minutes in your rebuttal time if you want to answer Judge Brownlee's
Sure.
question, and I'll credit the
Sure.
state the same. So go ahead.
So, Judge, I understand the court's point. However, I think the starting question is, how did the state put the defendant on notice of what charge he was supposed to defend against? And when the state explicitly said, we're going to charge you with trafficking in fentanyl, and the discovery shows that that's not what the state's going to be able to establish, and the legislative structure of the statute as well as the FDLE testimony supports that, the amendment mid-trial is the equivalent of dismissing the first charge and adding a completely new charge. And in light of the speedy trial context that we were playing in here, the appropriate remedy was to either grant a judgment of acquittal on the front end or to discharge the case after the amendment. I hope I did a decent job of answering that question for you, Judge Brownlee, but I'll reserve my time for the remainder of the rebuttal.
Good morning, may it please the court. My name is Roberts Bradford. I represent the state of Florida. And
Hold on 1 second, Mr. Bradford. Marshall, I'm trying to add 2 more minutes, and it's not going for me well. Whenever you're ready, counsel.
Thank you. The general rule here concerning mid-trial amendments is that the state may do so at any time unless there is prejudice to the substantial rights of the defendant. That's not just simple prejudice. Everything the state does prejudices the defendant. That's the whole point. The unfair prejudice, it's a due process type of prejudice, an unfair prejudice, I would suggest. The Thatch Court talks about the importance of not only recognizing and safeguarding a defendant's rights, but also when the court is looking at it, to ensure the prompt and efficient administration of justice. So it's not just the safeguard of the defendant's rights. And it is, on review, a totality of the circumstances. You have to look at the entire picture, the entire trial, everything up to that point. And I think that's why this argument, this appeal this judgment should be affirmed. The court recognized below that the defense had the FDLE report, I think it was 2 months before, at least 2 months before trial. Plenty of time. They could have filed a C4 motion to dismiss, but they didn't, and they didn't do that because it would have put the state on notice so that they would have made an amendment pre-trial.
Is that the defense's obligation to call the state's attention to a defect in the charging document?
Absolutely not. No, it is not.
And should we count it against them that they didn't do that, but that they elected to put the state to its proof and go to trial?
I think you should count it in the sense of your consideration of the prejudice to the defense. As my learned friend acknowledged up here before, this was a tactical decision. They saw the error compared to the information, and they just kept quiet, and they were going to ambush after trial started, after Jeopardy had attacked.
But it's a huge catch-22, right? If we hold that against them now, and I understand, I think that the case law really says, notice is a big deal here. I also think speedy's a big deal here, right? So they make this, huge strategy decision. But if you're that defense counsel, you're like, state said X, I'm going to trial on X this whole time, and you're like, you guys, they haven't noticed it. You'd probably be the worst defense counsel in the world if you were like, hey, state, you need to charge him with the Schedule 1 instead of the Schedule 2, or whatever, right? He's going to bring that to his attention?
No, I wouldn't.
Maybe he needs a backup plan.
When I did defense work, I certainly didn't bring stuff like that to their attention. You keep that in your back pocket. But at the same time, you have to prepare a plan B, because as soon as you get in there, they can amend the information.
Did they amend the
Right after the jury was
information
formed.
too late? He moved for a JOA. The state still didn't ask to amend the information. It's not contemporaneous. At first, I thought it was contemporaneous. The JOA, or excuse me,
Right.
the amendment happens with the judicial notice stuff.
Yes.
What is my timing like there?
The JOA, and I think this goes back to the point you were making earlier, that the Barrington, the FDLA expert, said it is a type of fentanyl. It is a fentanyl. And if you look at that factors in as well, because he was charged under the trafficking statute in the original complaint. He was charged under the trafficking statute in the amended complaint, 1C4A. Now, 1C4A is the fentanyl section of the trafficking statute. Starts off with cannabis, goes to cocaine, goes to whatever else. I think oxycodone is in there, the opiates, the methamphetamine. This section is the fentanyl section, and it includes all those different chemical constructs, and that's what the court ultimately said and found with respect to the amendment, is that you knew that's what they were talking about, this fentanyl section. And so
But it's not what they charge, right? And so I think this goes back to Judge Ganem's point, which was, to Mr. Solis, which was, what's our timing like here? If we just, I had a crim pro professor in law school, it was like, freeze frame. Where are we now? Where are we now? Where are we now? When he first moves for JOA, there's no effort to amend the information. So
Correct.
your position on that, is your sole response the FDLE agent's testimony? And I agree with you, that's what Judge Kranick said. The FDLE agent's testimony gets you past JOA because she said it's a type of fentanyl, has an extra atom.
In a light most favorable to the state, it is a fentanyl, is what was alleged in the original complaint. That's it.
Is that somewhat of a legal conclusion? So we have Ms. Barrington up there, and she can testify as to the chemical composition of these different substances, correct? But the statute, I think Mr. Reese's point is, the statute tells me that these things are different.
They are all different in the sense that they, and this is the convergence of law and science, in the fact that it has an extra fluorine atom. There is a different chemical construct. However, all of these chemical constructs are included within this subsection of the trafficking statute. It even includes fentanyl analogs, which he was originally charged with. He was originally arrested for the possession of fentanyl analogs, if you look at the original charging complaint. That's included, and analogs, as I noticed in the brief, are these new designer kind of drugs where you alter the chemical construct to get around so you can still get the same effect and you can still sell it as a drug, but then you're not violating the law because it has an extra fluorine atom. So the analogs, and essentially what that does is that information gives them a short and plain statement as it's required to do. It identifies the statute under which he's being prosecuted. It identifies the minimum mandatory that's applicable to whether it is a Schedule I, Schedule II fentanyl. It doesn't matter what type of fentanyl it is. It is a fentanyl.
Then why did they put it in there? Why does the legislature, they could just do they could do some broad statement, but they're delineating these. And the state, once the state puts it on notice, once the state says, you robbed, SunTrust and not Bank of America. Like once the state starts putting these particulars in there.
If I may, Your Honor, the Green case talks about the fact that there's a whole line of cases. I was just looking for the original quote. Here it is. The common thread in this line of cases, the ones that allow amendments, is the amendment is permissible when it merely clarifies some detail of the existing charge and could not reasonably have caused the defendant significant prejudice. He was arrested for the possession of fentanyl analogs. He was ultimately charged with trafficking in fentanyl. But again, the change from the original information to the amended information wasn't different except for the type of chemical that was there, but it was still within the same subsection. And I think the importance of that is there's that line of cases that the Green Court was talking about, whereas ones where it's clear from the discovery, he's on notice, he's clear from the discovery that we're all talking about the same thing. So in those battery on law enforcement officer cases where there's a whole bunch of officers involved and the state chooses these two, but then mid-trial chooses and goes with another one, that's different because you got all these different officers. But there was one case, I think it was Taylor versus State, that said if you've only got one officer involved and everybody knows who you're talking about, it's a typo. And if it's a typo, then you can change it and there's no prejudice to the substantial rights of the defendant.
So then it must be your point, because none of that relates to elements of the crime, right? I had to think about that, but I think I'm right about that.
You're right. I think you're right because when you talked earlier about the substance being inserted into the jury instructions.
Okay.
It says it would be fentanyl derivative or fentanyl, or because they're on notice that they're being charged under that section of the statute, and then discovery. Let's say they were being charged with possession of or trafficking in analogs, fentanyl analogs. They're not going to know until the FDLA expert is deposed or provides a report. They're not going to know what that substance is. It's flushed out during the discovery.
But the state could have amended its information at the same time that the defense became aware that it was parafluorofentanyl that you're talking about. The state could have amended its information then too, correct?
I have to concede that, yes.
So what if in this case we had a charging document that said trafficking in cocaine, and the discovery showed it was parafluorofentanyl, and the same motion for JOA is made, the same motion for amendment of the information is made. Would this case be different? Because it seems like it would be, because cocaine and parafluorofentanyl just aren't the same thing. There'd be no testimony that they were even close to the same thing. Would the state in that case have to concede? Yeah, we didn't.
They would have to
prove what
bring
we
charges under a different portion of the trafficking statute.
Right.
Now you're getting into the substantial rights of the defendant.
But it's all the same statute. So you have if this is all under cannabis, cocaine, fentanyl is all under subsection 1. then you start drilling down into the paragraphs and the subparagraphs and the sub-subparagraphs. At what level of specificity do we cross the line where it would be impermissible? Would we have to conclude necessarily that the state just failed to prove what was charged, as opposed to here where you're saying, well, the state didn't really fail to prove what was charged. We got close enough because they're in the same subparagraph. I mean, at what point do we cross that line to where it's okay and it's not okay?
I think you have to go back to the general rule that the state can amend its charging document at any time, even mid-trial, unless there is prejudice to the substantial rights of the defendant. And in the line of cases, there's some where they added a charge of purchase of cocaine to an existing charge of possession of cocaine. That's a whole new charge. That's got to affect your defense, but not in a substantial way that you weren't already on notice of, because the facts of that case were he possessed it when he purchased it from an undercover police officer.
But what if we have a situation like here, say there was a permissible, and I know what case you're talking about, but say there's a permissible substantive amendment, but a prior JOA. Like, it goes back to my freeze frame question that I think is related to Judge Yanham's initial question, which is, wasn't he just entitled to a JOA at that point? And I didn't have an ASA who said, fine, if he's going to get a JOA, I want to amend my information.
Well, that goes back to the quality of the game of gotcha that he wanted to engage in, which honestly, in this case, probably would have been pretty good up until the point that the FDLA expert said it's a fentanyl.
When you go to prepare the jury instructions, do you put fentanyl derivative or fentanyl? Do you put carfentanil? I'm learning a lot that I didn't know this,
Yeah.
but would you put that in the jury instructions, or you put fentanyl as the element, and then you say, as a matter of law, to Judge Nardella's question, carfentanil is a type of fentanyl, to help this jury, because they've heard a lot about carfentanil.
I think you would put generally my experience has been you track the language of the statute, you would have put fentanyl derivative, and you would have had your expert testify that that is a fentanyl derivative.
And you would put fentanyl derivative. That makes me feel like it's an element. That's what the ASA did in this case.
It's an element, but again, the statute didn't change. The essential element didn't change in the sense that you're still under the same subsection. You're still dealing with all these different types of fentanyls. You're still on notice 60 days before trial that it was Schedule 1, not Schedule 2. And you just want to play gotcha. His defense to the merits did not change. Not once, not a bit. He said, I took the xylazine, which is a Schedule 1, by the way, that he didn't have a prescription for. I take xylazine for pain. Okay, well, xylazine had already been brought up, so in regards to the opening the door, that didn't do it. But when he was asked about the white powder being in, I'm sorry, I'm getting off track. The defense was, I didn't know it was anything but xylazine. So whether it was parafluorofentanyl, a fentanyl derivative, fentanyl analog, fentanyl itself, doesn't matter. His defense was the same. Now he wants to play, he's saying he was only prejudiced because he didn't get to play gotcha. But he knew going in, gotcha might not work. So that's not a substantial impairment of his rights.
What if we disagree? What if we disagree with you about the testimony of maybe Agent Barrier or Barrington? Thank you, Judge Nardella.
Barrington.
So if it is a question of law as to whether this constituted fentanyl, then, she can't just make that determination, right? So what if we think that her testimony can't clear that JOA? We're like, that wasn't enough. That's a question of law. She can't, rectify this problem. Can you still get around the JOA?
What evidence do you have to contradict hers?
Well, whether it's a question of law.
So you think the judge can overrule the expert testimony?
I think that the judge decides, she can testify to things,
Well, the
sure.
judge has to take the evidence in the light most favorable to the state for the JOA.
I understand that, but the judge is still going to decide questions of law, right? That's not going to be a factual determination for an expert.
it's a question of law. Whether it is fentanyl, I believe, is a question of fact.
But
I think
whether-
Judge Nardell, yeah, go ahead.
But
Judge
whether
Wood, you can help me.
fentanyl is the same thing as parafluorofentanyl is a question of law so far as they're differentiated in the statutes.
How they're treated under the statute, yes.
Okay,
This again goes back to the convergence of law and science, but the evidence before the court was, it is a type of fentanyl. If it's a type of fentanyl, then the state made its sufficient showing under the first information and survives the JOA. Then it chooses to amend it. Sure, okay.
well, if they choose to amend it, yeah, I guess my question is that I think I've asked it many different ways, so I'm not being clear about this. Is there a way under Florida law where if he was entitled to a JOA, say the court hypothetically gets it wrong, just gets it wrong, they go, right, which would be Mr. Soris's point, is it cleaned up by a subsequent cleaning up of the charge? Like, is it harmless once it's sort of cured on the back end by the state? Or is that a timing problem for the state?
Maybe I misunderstood the question. If the JOA is granted, trial's
No.
over.
Right. Yes. Then we
Yeah.
wouldn't be here at all. I'm saying denied, right?
Okay.
I'm saying you wouldn't agree with this, right? But say if the trial court denied erroneously the JOA, but then cleans it up. It should have been granted, but then whatever happens, it's kind of cured on the back end. Now is the whole thing
Oh,
cured?
I see.
Or are we freeze framing where that error happened, they should have walked out of that courtroom? Can you cure that? If you don't know, you don't know. I just thought I would ask, so I have you here.
I can't say for certain as far as I've read a case on that, or I remember an instance in dealing with that in the trial court. A lot of times they get into it in the discussion, and they kind of move to amend during the discussion.
Yeah.
And I see what you're saying here afterwards. I don't think so, Your Honor. I think, well, I mean, we can speculate in terms of what ifs, but the bottom line is that the expert said it's a type of fentanyl. And so the question of whether you survive the JOA, I think, is foreclosed. You do, because you have to take it in a light most favorable to the state. If it's a type of fentanyl, and fentanyl was alleged, that's good. With respect to issue number 3, which I assume my learned friend is going to address on his rebuttal, the state tried a couple of times to get in these other drugs, and the trial judge shut them down very quickly. They tried pretrial, didn't work. They wanted to get the crack cocaine in. Then before the cross-examination started, the prosecutor approached the bench. I want to get into it now. Is that okay? Nope, still not opened the door yet, because, and I don't think the trial judge got into it this far. She just said he hadn't opened the door yet. Because the only thing he brought up on direct examination was the xylazine, which had already been discussed by the FDL expert. But then he said that he used it for his scoliosis, and he was asked, do you go to the doctor about the scoliosis? And he goes, no, I usually just smoke pot or take drugs. And then there was an admission he didn't have a prescription for what was in the pill bottle, and then you had the white powder in the pill bottle. Well, yeah, and some Xanax too. Now he's thrown in cannabis. Now he's thrown in alprazolam or Xanax, whatever you want to call it. He did that on his own. He opened the door. I think that's pretty clear. And then the state approached the bench again, made another motion. Yep, everything's fair game at this point. And he admits that he takes crack cocaine, Xanax, xylazine, and cannabis, at least, for his anxiety, for his scoliosis, so that he can work. That was his defense. He still made the same defense, whether it was parafluorofentanyl or whether it was fentanyl. The substantial rights of the defendant were not affected. Unless the court has any additional questions, I'll rely on my brief for the remainder of the argument and ask this court to affirm the judgment in all respects.
Whenever you're ready, Councilman.
Sure. May it please the court, just a few points on rebuttal, and in light of the court's apparent curiosity on the first issue, I'm going to spend my 3.5 minutes on just that first issue. So the first thing I would point out is this idea that the defense was on notice. I consider that to be a red herring. I think that's the whole point of this argument, is that the first thing that the defendant learned is that he was charged with trafficking in fentanyl specifically, as specifically cited in the information. So the fact that the defense subsequently learns through discovery that the controlled substance is not what was charged does not mean that he wasn't prejudiced, or it doesn't mean that that precludes him from seeking a JOA or a discharge after the mid-trial amendment. The whole idea was the state incorrectly charged the crime. There was a charging defect in the jury, or in the charging document, and it's not the defendant's responsibility to bring that to the light of the state.
But did they know the defense knew as of December 4th, 2023, when they received that report, that it was parafluorofentanyl and not as charged?
Correct.
I mean, I think with regard to notice, I think you're right. I mean, there's a problem with the charging document. However, to me, the point of notice is your ability to prepare the defense, is to get those bench notes from the FDLE, to do all of these things and to actually be able to prepare. Whereas if the state switches it mid-trial, and they take away your alibi defense, for example, you have no way to prepare. We got a due process problem here. But y'all knew, not you, right? The defense team knew over a month prior to trial, and then built their case this way. So they knew and consciously made decisions that I get, and did that. So to me, they're on I at least think they're on notice.
So, yes, Judge Brownlee, although I think the proper inquiry is to hold the state accountable for how it charged the crime. And so when they ground the criminal charge in subparagraph 9, which specifically delineates fentanyl, and then the defense builds its case around that, I think the more appropriate inquiry is to hold the state, and that's what the case law says, is to hold the state accountable for how they charge the offense. And subsequently, when we're at trial, the evidence has to conform to that.
This prejudice issue, maybe the question is like, from what perspective do we consider prejudice? Is it always reasonable for the defendant to rely on the charging document in building the defense, such that even irrespective of what evidence shows up in discovery, the defendant can build the defense on the charging document and then argue prejudice if the state tries to change the charge midstream? Or is the prejudice looked at from the perspective of, did you know what was coming? In other words, once you saw the discovery, even though you knew of the defect in the charging document, you had to be prepared for the fact the state would do this thing that's not that unusual of amending the information mid-trial. From what perspective do we look at or try to measure that prejudice? I think in the Holland case out of the first DCA, there was a question to the defense counsel was, well, what would you have done differently had you known about this? And in that case, the defense counsel said, no, nothing. And so later on, the court concluded, well, we don't think there was any prejudice. But is it really just a matter of the defendant choosing how to defend the case based on the charging document, and that sort of locks in the prejudice inquiry based on that perspective?
We would argue, yes, that it's that former inquiry that you described, Judge Ganim. I think in an instance like this, when I say I'm over my time, if I may, in an instance like this where the state explicitly lets the defendant know in its charging document that it's giving him notice of a particular controlled substance that's being trafficked, I think the prejudice, even subsequently learning that there's going to be a different controlled substance that's coming in at trial, I think the prejudice is the defense relied on the specific charging document, prepared an entire defense based on that specific charge, and then as the trial counsel described it below, the rug was completely pulled from underneath him after he moves for JOA, after he brings the evidence issue or the defect to the court's attention, to the state's attention. The state subsequently amends the information to conform with the evidence. I don't see any other clearer example of acknowledging the defect and the evidence problem here. And so for those reasons.
And
unless
one
there
more
are any
question,
other
counsel.
questions, yes.
So what is your best point to the state's position that, well, he had to deny the JOA because the FDLE agent got on the stand and said it's fentanyl?
Well, I think the court was touching on it. I think you have, on the one hand, the FDLE expert testifies that they're separate and distinct. She actually explicitly says on cross-examination that parafluorofentanyl is not fentanyl. On the other hand,
Because it has like one extra atom, but then she says it's a type of fentanyl.
sure, but I'd go back to the Florida legislature's delineation of these. They exclude fentanyl from being a fentanyl derivative. So, to answer your question as most directly as I can, Judge Brownlee, I think it's a question of law, and I think if this court determines that, even in light of the expert testimony, we have a statute that delineates these controlled substances differently. If the state did not, if the state proved one controlled substance but didn't admit evidence of that substance, then I think the JOA should have still been granted, and I think that this court can make that determination as a matter of law.
Counsel, what do you do? So they do delineate it, you're right, and we've talked ad nauseum about that, but then they go on to say that if you do these things and you have these substances, it shall be known as trafficking in dangerous fentanyl, that catch-all.
Sure, and I think, Judge Brownlee, this might have been your first question right out of the gate.
I'm troubled.
Sure. I acknowledge that particular provision. I think it does add a wrinkle to this entire argument, although I would stand on the notion that the legislature did not lump all these controlled substances in together. I understand that there's a provision that says this is what we're going to call this crime, but I think the more pertinent statutory provisions for this court to grapple with is that subparagraph 62 versus subparagraph 9 in 893.03. And so because they're delineated separately, given different definitions, and have different chemical and legal constructs, the judgment of acquittal should have been granted at the outset. Barring any additional questions from the court, we'd ask the court to reverse and remand with instructions to dismiss this case. Thank you, Your Honor.
I want to thank both counsels for their argument and their briefing today.